Cameron at Soren Law here, and today we're going to be talking about Bostock versus Clayton County. Now, to begin, we need to go back to 1964 when Congress passed the Civil Rights Act. Now, the Civil Rights Act was aimed at a host of different things, but essentially the main thrust was to prohibit discrimination on the Big Five statuses, categories. Discrimination on the basis of race, color, religion, sex, and national origin. Now, the Civil Rights Act is broken into several different sections known as titles. And some titles are aimed at prohibiting unequal application of voter registration requirements. Others are aimed at prohibiting segregation in the schools, public accommodations. Then you've got Title VII. Title VII is specifically directed at discrimination in the employment context. And to really bring it down to the main thrust, it prohibits an employer from discriminating on any of the employment terms because of the employee's race, color, religion, sex, or national origin. All right, that's what was originally passed in 1964. Fast forward towards today. The Supreme Court granted certiorari on 3 cases, 2 of which involved individuals alleging that they were terminated on the basis that they were homosexual, a third alleging that they were terminated on the basis that they were transgender. Now, the Supreme Court heard oral argument on the 2 cases dealing with alleged discrimination on the basis of homosexuality, separate from the one involving transgender. But ultimately, the court issued a single opinion addressing all 3. And the short version is that discriminating an employee on the basis of being gay, lesbian, or transgender violates Title VII. Justice Neil Gorsuch wrote for the majority, and he was joined by Chief Justice John Roberts, along with Justices Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elena Kagan. Now, Gorsuch begins the opinion by explaining that the Supreme Court generally interprets law by looking at how the public would have understood it at the time the law was passed. The ordinary public meaning of the law, the ordinary public meaning of the words. Here, Gorsuch reasons that the word sex would have meant either male or female. So under the plain terms of Title VII, an employer violates Title VII when it intentionally terminates an employee, in part based on sex, even if other factors besides the plaintiff's sex contributed to the decision. The whole point is does it ultimately play a role? So he uses a particularly illustrative example. You've got 2 employees. They are identical in every way, including both of them being attracted to men. Now, one employee is male, one employee is female. If the employer terminates male employee, in part because he's attracted to men, but keeps the female employee, then that employer has discriminated on the basis of sex and therefore violated Title VII. Now, Gorsuch rejects the idea that because Congress did not specifically address LGBT status in Title VII, that Title VII somehow cannot protect LGBT employees. As Gorsuch explains, discrimination against LGBT employees necessarily entails discrimination on the basis of sex. The first can't happen without the second. Then Gorsuch moves on to one of the employer's arguments that Congress has considered but has failed to pass bills that would clarify the Title VII protections applied to LGBT employees. Now, Gorsuch points out that we don't know why those bills didn't pass, but one reason may have been that Congress thought the protections already extended to these individuals. More importantly is that speculation why later Congress declined to adopt new legislation is a fairly sketchy basis upon which to rest an interpretation of an existing law, an existing statute. Gorsuch then moves on to the next employer's argument, which is that most people in 1964 would not have expected Title VII to apply to LGBT employees. Well, Gorsuch respectfully, sort of concedes the point that yes, most people probably would not have, though he does point out some lawsuits in the late 1960s and early 1970s to counter that at least some people foresaw this potential application because it was filed by LGBT employees seeking protection under Title VII. Now, the real reason Gorsuch ultimately rejects this argument is that Gorsuch observes that most, maybe most, but definitely many applications of Title VII's sex provision were unanticipated by Congress back in 1964. And that has not been a bar on all of those other items, so it shouldn't be a bar on this one. Gorsuch ends up wrapping up the opinion by addressing the other issues that could potentially apply when you're talking about LGBT employees. That is, bathrooms in the workplace, locker rooms, dress codes, things of that nature. And Gorsuch stresses that the court is not ruling on anything related to that. All the court is ruling on here today is whether terminating somebody because they are gay, lesbian, transgender violates Title VII. The answer to that is yes. We're not going to be addressing these other ones. We may ultimately have to do so at some point, but we're not doing that here today. All right, so then we move on to the dissent authored by Kavanaugh. And he's out on his own on this one. He's not joined by anybody else. Now, Kavanaugh's dissent essentially is in complete agreement in terms of how the Supreme Court should interpret law. That is, you look at the ordinary public meaning. But where he differs from the majority opinion is that the ordinary meaning is not the same as the literal meaning, and that the court should employ the ordinary meaning. And here in Kavanaugh's view, the ordinary meaning, discrimination on the basis of sex, would not extend to discrimination on the basis of sexual orientation based on how that would have meant, how people would have interpreted that back in 1964. Kavanaugh also spends a section of his dissent clarifying or hammering home, in case it was not clear, that he has no issue with these types of protections being extended to LGBT employees. He is specifically addressing the question of whether or not this protection is in fact included currently under Title VII. Justice Alito wrote another dissent and was joined by Justice Thomas, and it was a particularly sharp one. Essentially, Alito accused the majority opinion as being a pirate ship flying under the flag of textualism, but ultimately carrying something else. Essentially, what Alito is criticizing here is, in his view, the majority has engaged in updating a law based on evolving values in society, rather than based on how it actually would have been interpreted, would have been read back in 1964. So, ultimately, now it is illegal for an employer to terminate an employee simply based on their sexual orientation or for being transgender. It's not that sort of didn't ultimately cover it. So it's a major decision, and it is sort of interesting to see that ultimately I think a lot of people might have anticipated if it was going to extend this protection to these individuals under Title VII, that you were likely going to get Roberts. I think it may have come as a surprise to a lot of individuals that Gorsuch was on board as well. But it was Gorsuch that ultimately wrote the majority opinion, and I think that reveals a little bit of his attitude when it comes to statutory interpretation. That, hey, he may be, for I guess the common term is a bit more conservative on certain constitutional items, but when it comes to statutory interpretation, He's a bit more middle of the road than I think a lot of the public perceives, or at least thinks he is. So it's always a good counter example of where Gorsuch really is at in his judicial philosophy. As always, hope you found this enjoyable and informative.